Hancock, members of the committee, thank you. My name is Bryan Blevins. I'm here on behalf of the Texas Trial Lawyers Association. We appreciate the opportunity to be here today and also to have worked with Senator Hancock, Chairman Hancock, on the bill.
Was there any question about whose committee it was?
No, sir.
Whose bill?
Nor today. But despite that opportunity, we still do have significant concerns with SB 10, and we are in opposition to it. The materials that we provide focus on three areas. One, Texas is a severe weather state. In fact, it's been voted the most severe weather state 2 out of the last 3 years. We're the only state that has all 9 major insured weather events. In 2015 alone, we had 783 hail suits, and we had 228 reported tornadoes. So this is a statewide problem. It's certainly a very serious issue, and I appreciate the committee's interest and the legislature's when it asked for information from TDI. I think the TDI information, which we've provided excerpts on, does provide some interesting information. Clearly, the concern is increased lawsuits. We see that in the data, no doubt about that. I still think it leaves the question of why. Because when you look at other parts of the TDI data, what you see is that the impact of that is approximately 2 cents per dollar of premium. We also see that in South Texas in 2012, there was an extraordinary spike. That spike was 56% of all of the claims filed a lawsuit. It was an extraordinary spike, and if you take that one spike out of the data, then all of the data points go back to historical levels. Also, you have to look at insurer conduct, because what we see in the TDI data is that, one, TDI found that insurance companies are using less time to investigate claims before they close them the first time. Secondly, that they have now increased the number of claims closed at the first close with no payment made by more than 30%, and that they have to reopen 1 out of every 3 claims. So while we are and recognize the concern about increased lawsuits, we also believe that there are insurer conduct issues that may be responsible in part for that problem. Despite that, we've certainly looked at the bill. We've had an opportunity to review the committee substitute. First of all, I think it's important to understand it treats all policyholders the same. It doesn't really distinguish between a good claim and a bad claim, or a frivolous claim and a legitimate claim. 18% penalty, which we were strongly in favor of, has been reduced to prime plus 5, and that's now held to property owner claims. So we're not sure the distinguishing. We believe in the 18%, and so why one policyholder type claim that's in bad faith gets the 18% and another one gets a lesser rate is not really clear. Beyond that, it basically will remove all cases, business cases, particularly to federal court, because you can't sue adjusters and agents, and over 80% of the insurance in this state is sold by foreign companies. I'm happy to take any questions on the bill.
Members, any questions? Senator Hancock.
Yeah, Brian, a couple of things. So if I take the number 100, and I just look at 100, 100's 100, right?
Yes, sir.
So if I take 100 and then I take 0 and now I divide by 2, I got 50, right?
I think so, yes, I'm following.
So if you say that if you take the abuse that took place down in the valley out of the equation, that number is really high. Because if you add everything else into that, that's at normal levels, we still had a 1,400% increase.
I'm not sure. The way I read the data, Senator Chairman, is that there were Hidalgo County represents approximately 3.6% of the claims that were in the sample, but 56% of those claims filed a lawsuit. And that's a huge, so for instance, if we're talking about a 1% filing lawsuit, that means that in Hidalgo County it was 56 times that number.
Right.
So if we take that number out of it, because of the small number of claims, then I think we get back to historical levels.
All right, which tells you how abusive the situation was in Hidalgo, that we would, when you couple that and you put that in with the whole pile, you still had a 1,400% increase in litigation. Don't you think a 1,400% increase since 2011, would you consider that a small or major problem?
Well, I certainly understand the concern with 1,400. I understand that that's the concern and that's the problem.
Is that a small or is a big problem, 1,400% increase?
Well, I understand the concern of that increase, but I
appreciate you understanding it. I just want you to answer me. Is a 1,400% increase a small or a big problem for the state?
I guess that would depend on what kind. If you're talking about lawsuits here,
Well, it
I
might
understand your
depend on
concern.
which side you're on, but I don't think for the state, maybe not your association, but for the state, a 1,400% increase in litigation, is that a problem needing to be fixed?
Again, I don't know how you can fix that problem if you don't know
it's
why.
Okay, Brian.
Chairman,
you don't have to answer it.
Chairman, if you don't know why, that's the problem. The data tells us there's been a 1,400% increase, but the data doesn't tell us why. In fact, most of the conclusions that TDI had were that the lawsuits they could not conclude that the lawsuits were causing those impacts.
Brian, that's okay.
Senator Campbell.
Thank you, Mr. Chairman. Just not doing the math, but if that's just one county, Hidalgo, then I think coming in and putting guardrails up, because we have 254 counties total, I would hate to multiply that by 253 more counties. So coming in and, with the trying to do the right thing so that we don't have a multiplicity here, I think is responsible for the Texas citizens. Thank you, sir.
Senator Zaffarani.
Thank you, Mr. Chairman. Sir, in your written testimony on page 1, in your bullet list, you say that this bill gives immunity to insurance agents and adjusters regardless of their conduct. Do you mean that in this bill, even if an insurance agent or adjuster engages in egregious conduct, that person still has immunity?
Yes, ma'am. You can't see there's no cause of action against the agent or the adjuster. And so because over 80% of all the insurance is written by foreign insurance companies, that means almost all business claims and a vast majority of home claims would be removed to federal court and out of their local state courts.
Your written testimony also says that the bill rewards slow pay tactics.
Yes, ma'am. By slashing the penalty. Under current law, it's 18% is the penalty. Under the present, it's prime plus 5. And that's only for property owners. We're now distinguishing property owners at a lesser penalty rate for the exact same late pay conduct as might occur in an insurance disability claim or an health insurance claim.
And could you explain the importance of going to federal court versus staying in state court?
Studies show, in fact, recently the federal courts in Texas were awarded the annual Slowpoke Award. What we've seen from the data is that federal courts, it takes almost twice as long to resolve cases as it does in state court, and also federal courts tend to generate more increase in costs.
That's pathetic. You have those figures?
Yes, ma'am. We can provide those to you.
I would love to see them.
Yes, ma'am.
I thought the state courts would get the Slowpoke Award. Can you tell us? Pardon?
Sorry, Senator Zaffarani, if you don't mind me, I will correct. The first part was maybe in the Senate bill, but not in the committee substitute, and so there maybe need to be a correction on his part on the litigation of the individuals.
Under the committee,
the adjusters or
under the committee substitute, you still can't sue. You can't bring a cause of action. You can't sue the adjuster or the agent, and so that's what creates federal diversity when you're against State Farm or Allstate or Farmers Insurance, which results in you going to federal court. The issue that you addressed, Chairman, in the bill was this question of an empty chair and whether or not there was no way to allocate liability at the trial of the case, which would now occur in federal court. The problem that still exists there, though, is that these witnesses now are no longer anyone's control. When they're made a party, you can then require them to collect discovery materials, produce discovery, be there for a deposition, be at the trial, whereas under this process, you could only subpoena them if they were within subpoena range. So there's still some control of the witness problems, even though I see the language that's attempting to fix the issue of the empty chair.
I would tell you that his answer to you was not completely accurate.
Thank you. In your written testimony, you also referred to the inspection process and indicate that that is slowing the entire process. Could you explain how?
Well, that has been addressed. Again, we did not have the benefit of the committee substitute until late yesterday. So as a result, that analysis was done on the original bill. There were some changes made to the inspection process, which changed the format of that. And so now at this point, it becomes an affirmative defense if the defendant has not been allowed to do their inspection.
All right. You also referred to conflicts in representation.
Yes, ma'am. There are several, Senator. There are at least 3 or 4 different ways that the bill addresses the award of attorney's fees to the plaintiff, makes a decision of the attorneys relative to the plaintiff, or in the context of barratry, could outright conflict out the client's choice of counsel. So there are a number of issues that we've never seen anywhere else in Texas law dealing with attorney's fees, with the post ex facto disallowance of attorney's fees, or taking a claimant's, the actual policyholder's claim is who holds the barratry claim, and we're now actually giving that under this bill to the insurance company to use against the policyholder.
And Senator Zaffarini, I'd say that some of that is misunderstanding from not having a proper time with the committee substitute, and so we'll be.
Thank you. Thank you, sir.
Okay,
Mr. Chairman?
Thank you, Mr.
Yes, Senator Taylor.
This part you talked about the immunity for agents and adjusters. Are you talking about on page 7 of the committee substitute?
Yeah, I think he probably needed a lot more time with the committee substitute based on his answers.
Yeah, because I'm reading they only get that if the insurer agrees to take on their liability. So the suit would still be there. It's just that the insurer is taking on that liability of the agent or the adjuster because they're acting as on their behalf and as their agent in that call. So, and if they don't do that, I don't think you have immunity for the agent or the adjuster.
I do agree that if the insurance company does not make that election, then you're right, the insurance agent or adjuster can be sued. But if the insurance company
Hold on a second. That's not what you told Senator Zaffarini. I thought you...
Again, I assumed that the insurance company would be making that election.
So,
yes, sir.
I mean, I hate to say I told you so, but so I was accurate, and maybe your statement was not completely accurate.
Only to the extent, Chairman, that if the insurance company doesn't make that election, you're absolutely right, then you can sue the adjuster or the agent.
Right,
if
and I
they
was
make
just trying
that
to
election,
clarify that you weren't completely accurate.
And again, to that extent, yes, sir, that's correct. But if they make that election, then you can't sue the agent or adjuster is the way I understand it.
Right, you just left that out when you answered Senator Zaffarini's question. Would you agree?
Actually, Chairman, she asked me about when it was creating immunity, and that is the circumstance where it does.
I think she asked if they were immune, and you said yes.
And again, I apologize. I'm not trying to be wordsmithing here. I'm just saying that when under the bill, it is the insurer who has the right to make the election to take on that liability of the adjuster, and when that happens, you can't sue the adjuster or the agent. That's my only point.
And you may not be trying to wordsmith, but you're pretty good at it, and so I'm just trying to clarify where you do wordsmith. Thank you.
Mr. Chairman, if I could.
Senator Taylor.
And if under that same discussion, I think you also said they couldn't use the evidence of the agent or the adjuster. And if you look at page 8, on line 8F, if an insurer makes the election available to it under subsection A and the agent is not a part of the action, evidence of the agent's acts or omissions may be offered at trial, and if sufficient evidence supports the submission, the jury may be asked to determine the agent's responsibility for claim-related damage caused to the claimant. So I think you misspoke on that one as well.
Actually, Senator, that's the part that I specifically addressed was in the bill, that we were trying to solve the empty chair problem. The issue that I was addressing is that if the insurance company elects to take on that responsibility and you can't sue the agent and the adjuster, then what you can't do is you can't control the witness. You can't ensure that information's being marshaled. You can't ensure that they respond to discovery. You can't ensure that they're at deposition. You can't ensure that they're at trial if they're outside the subpoena range.
Are you saying that they can or they can't?
You can't do those things if you can't sue them, again, assuming that the insurance company has made that election.
That doesn't look like what I'm reading, but we'll have someone else, I guess, discuss that further. So.
Yeah. And, you know, I will recognize that he didn't have an abundance of time with the bill, so he may not have everything accurate. Thank you.
Senator Zaffarini.
Sir, you were involved in Senator Hancock's meeting.
Yes, ma'am, I was.
All right. And did you feel that there was thorough negotiation and compromise and consensus reached as the bill was developed, or to what extent was it?
Well, I certainly don't want to necessarily comment on Chairman Hancock's meeting because he can certainly address that. What I can tell you is that there were parties representing all issues there. There was an opportunity to go through the bill and review it extensively. There was an opportunity to discuss concerns. And there was a discussion of some potential concerns and the invitation of the opportunity to bring some language to some of those concerns.
But you didn't feel consensus was reached?
Again, we raised a number of concerns that are not addressed in the committee substitute, and so our concerns are still very significant regarding the bill. Again, that's no disparagement of the meeting or the process, because we certainly were there, we participated, and we were given an opportunity to participate.
But under no circumstances should anyone think this was an agreed-to bill?
No, it's not an agreed-to bill.
Thank you. Thank you, Mr. Chairman.
And Senator Zaffarini, he is registered against. And let me be clear, when we started this process, in no way did I think with a 1,400% increase in litigation and the financial benefit of that, did I think we were going to get to a point that everybody could be in agreement on it. There's way too much money involved with 1,400% increase in litigation for me to think that somebody's pocketbook was not going to be hurt significantly, and I anticipated that there would be those that would be in opposition to this.
Okay, members, any other questions? All right. Thank you, Mr. Blevins. Go ahead.